Next, I'll introduce Teresa Nobre. Teresa is an attorney based in Lisbon, Portugal, and a legal expert on copyright with the Comunia International Association on the Digital Public Domain. She's also the lead for Creative Commons in Portugal. She coordinated research projects, educational resources development, mapping copyright exceptions and limitations in Europe in 2014, and the best case scenarios for copyright, also published by Comunia in 2016. Teresa is actively involved in the copyright reform debate in Europe, and she's the legal lead of Comunia's current campaign, Right Copyright, to fix copyright law for education. And over to you. Thank you.
Thank you, Tira. Hello. I don't have slides, but I have data. And I think data is important, so I would highly recommend you to take some notes from my data, because it's highly difficult to find data on the issue that I'm going to talk about, which is technological protection measures. So as you know, the current version of the Broadcast Treaty obliges contracting parties to provide adequate legal protection and effective legal remedies against the circumvention of effective technological measures. Nothing is mentioned in the current proposal about the need to provide for flexibilities, limitations, and exceptions to the protection of those measures. And this is very concerning because I recall a study by Professor Daniel Sang on educational exceptions, a study with more than 1,000 pages, but in one of those pages it mentions that about 60% of WIPO member states do not provide for any flexibilities, exceptions, or limitations of technological protection measures. I recall that when technological protection measures were first drafted at the international level, they were expected to protect TPMs insofar as they restricted acts not authorized by right holders. But in the EU, for instance, and I have some data from the EU, which I think it could be useful to think about these issues. So in the EU, the laws are completely blind to the intent of the users. So users are prevented from circumventing technological protection measures, regardless of whether their aim is to infringe copyright or just to exert their legal rights under copyright exceptions. As a consequence, TPM is blocking the use of works under copyright exceptions on a daily basis. And we have attempted to find data in the EU on the daily impact of TPM on users' rights. Unfortunately, as with many other aspects related with the impact and effectiveness of copyright laws, there is not much data available. But fortunately, the European Commission did an impact assessment study previously to this new proposed directive in 2016 on digitally supported educational practices. And in this study, it includes an analysis of the effects of technological measures on users. So bear with me. Technological restrictions were characterized by teachers and students that were surveyed as the most frequently encountered copyright-related obstacle by users of digital works in education. We are talking about 31.2% of educators and 36.9% of learners that stated they are not able to access, download, use, or modify a digital work because of technological protection. So more than 1/3 of the educational community in Europe that was surveyed in this study said that they cannot access and use, at least not immediately when they need it, works protected by technological measures. And this happens because in the EU, for someone to use TPM protected works, it has to go through a mechanism that is supposed to be on the laws, but the fact is that these mechanisms are lacking in 20 member states. The EU has 28 member states. In 20 member states, there's no mechanisms foreseen in the law that would define what is the procedure that a user has to follow in order to have access to the TPM protected work. So member states in the EU are obliged to ensure that TPMs do not prevent users from benefiting from the copyright exceptions. And we know for sure that these mechanisms are available to end users, vary widely between member states. But apparently, the majority of the EU countries do not even have such mechanisms in place. And we are talking about the EU, okay? So EU is supposed to have modern laws, modern mechanisms. So the law says you have to implement mechanisms, and 20 don't have any mechanisms. In this study that I mentioned, this impact assessment study by the European Commission, local copyright experts that were consulted, they say that they have not been able to identify, so I really want to reinforce that, they have not been able to identify clear mechanisms which may be activated for using TPM protected works under exceptions and limitations in most countries. So the study is not even referring just to educational exceptions, but to all types of exceptions. There's no mechanisms. So only 8 EU countries have such mechanisms, and these mechanisms, even when they exist in these 80 countries, they can be very burdensome. And I'm going to give you some examples. So for instance, Germany, Spain, and Sweden, they require the user to go to court to defend practices that should definitely be guaranteed in order to exercise exceptions to copyright. In France, Italy, Norway, Slovenia, United Kingdom, it is necessary to file a complaint with the relevant authorities or open a mediation process. So of course this all takes time and effort, and thus is not providing the necessary access to users. I'm a teacher, I need this to teach my class, this material. I cannot go through a mediation process that can take weeks or months, because when I finally get the access, my class is over, and or even the year is over. So it's definitely not possible to work like this. But this scenario is not even unique to the EU. So I recall Professor Sang's study again, and he has tried to analyze the manner in which the provisions of WIPO member states provide that TPMs can be circumvented, removed, or disabled, or access can be granted. And he has concluded that this varies a lot. So he says that some provisions oblige or require the right holder to lift the TPMs, alter their works, or make available appropriate means to enable the purposes to be achieved. Many of these provisions, says Professor Sang, further require the use to engage the right holder to negotiate a solution to the impasse, and other provisions, better provisions, in my opinion, simply entitle the beneficiary to circumvent, remove, disable, or destroy the TPMs or DRMs without penalty or damages. In the EU, 2 countries at least have followed this path to allow circumvention. So, for instance, Poland never implemented the anti-circumvention rules, and Portugal, my country, just revoked them. And we revoked the anti-circumvention rules after complaints by users and advocates of users' rights to the parliament, to the Portuguese parliament. The parliament decided to listen to all parties involved. They listened to right holders, to users. The right holders went to the parliament and were asked, what are the means that you have, what are the mechanisms that you have to give access to users that want to use TPM protected works? And most of the right holders, I heard that all of the right holders in Portugal said, we simply don't have access to technical means, because those technical means come, we local organizations don't have access to those means. That's why when we are requested in Portugal to give access, we are not able to do it. So it appeared that it was so complex, the process. The local organizations would have to require to the international organizations, and they were never able to get those means, that in the end, the Portuguese parliament decided to infringe EU law and revoke the anti-circumventions rule. So now in Portugal, when a user wants to have access to TPM protected works and is not able to have access to the technical means that would allow him to have access to TPM protected works is highly complex, the user can simply circumvent or remove the TPMs. In conclusion, I think right now technological protection measures are enjoying of such a strong legal protection that they could progressively, and I'm not the first person to say this, I'm just copying an idea, but I really think this is the case. They could progressively replace copyright laws. And the data that we have shows that they are indeed, at least, if not replacing copyright law, they are restricting and prevailing over copyright exceptions and limitations. Therefore, it's essential for WIPO member states to understand that they cannot simply provide for the protection of technological measures without defending the rights of beneficiaries of exceptions and limitations to access and use TPM protected works. And we have a proposal that was submitted after the informal sessions at the SCCR 34 that is intended, it's called Proposal on Obligations Concerning Technological Protection Measures. I have no idea which countries proposed this, I'm sorry, but it says specifically contracted parties shall take appropriate measures as necessary to ensure that when they provide adequate legal protection and effective legal remedies against the circumvention of effective technological measures, this legal protection does not prevent third parties from enjoying content in the public domain, as well as the limitations and exceptions provided for in this treaty. I think this is a start. I would go much further. I would make it much more concrete and provide for different levels of guarantee of the user's rights, but I have not been able to devise those rules. I'm happy to work with delegates that consider this issue important, that might want to introduce such rules. Thank you.
Thank you, Teresa, for your data-rich presentation. And I was wondering, even though you didn't have slides, hopefully, if there's some of the data, and if you could share your presentation with us later on, I think for the delegates and for people watching on the webcast, I think it would be really useful, especially on what you have shown on technological protection measures.